This is Wendy Barlow from Cohen Tucker and Adis. It's been a while, but I'm back. Natalia's a little busy today. So today I just want to go over some new updates coming from USCIS. There are a few things that have been recently announced or are important deadlines coming up. So let's start. H-1B. H-1B electronic registration period has officially closed. It closed on Monday, March 20th. Now, all those individuals and companies who filed registrations are waiting for USCIS to make the selections. USCIS intends to announce selections by March 31st. You will be notified through your My USCIS account if the H-1B registration has been selected, and then you can continue with the processing. The first day that you can file H-1B petitions is April 1st, 2023. It is very important that if you are selected or your company's registration is selected, that you quickly get in that H-1B petition so the process can continue moving forward, and your employee will have approval and can begin working on October 1st in H-1B status. Moving on with USCIS, ever since March of 2020, USCIS has implemented guidelines regarding COVID-19 that have allowed for additional time to respond to things like a request for evidence, notice of intent to deny, notices of intent to revoke, continuances regarding naturalization, notices of intent to rescind, lots of different things. Essentially, you were given 60 additional days from the deadline to respond. That covered request for evidence and the other different notices I mentioned issued from March 1st, 2020 through March 23rd, 2023. What that means is for any RFEs or notices of intent to deny or notice of revoke issued after March 23rd, 2023, you are now subject to the filing deadline as set forth in the actual notice. This means if you're supposed to respond to the RFE in 89 days, your response is due in 89 days. If your notice of intent to revoke gave you 30 days to respond, you must respond in 30 days. USCIS will no longer be considering those responses that are filed after the deadline, but within 60 days thereof. Also, this impacts I-290Bs, which is notices of appeal or motion, as well as Form 336, which is a request for hearing on a decision in naturalization proceedings. Before, you had up to 90 calendar days from the date the decision was issued to timely file those petitions. That is ending as well. This means that the deadlines that are set in the decisions are the ones that you must adhere to moving forward. I know our office has been trying to comply with deadlines regardless of the automatic extension, but I will admit the automatic extension has been nice at times, but that is coming to an end. Another update from USCIS and the State Department as well is related to visa availability for the EB4 category. While EB4 implies it's an employment-based category, and there are visas that are issued in that category for employment-based cases, it also covers applicants for green cards under special immigrant juvenile status. For a very long time, Honduras, El Salvador, and Guatemala had their own individual per country allocation, which meant that their visa usually they were oversubscribed. So they were waiting for visas. The rest of the world was pretty much current, give or take, depending on the particular visa bulletin. But as a general rule, those countries were oversubscribed and were subject to about a 3 to 4 year backlog. As of the April 2023 visa bulletin, those individualized categories for Guatemala, El Salvador, and Honduras have been eliminated. That means that they're essentially going to be allocating visas across the board, no matter what country a person is from. And this has caused the demand for those visas to be oversubscribed in all areas. We're looking at visa availability for 2018, which has now pushed eligibility for applications to adjust status for special immigrant juveniles to 5 or more years. Hopefully, as things move forward, that those wait times will go down. Unfortunately, I really don't see that happening because demand seems to be increasing more and more for those visas. But we shall see what happens. But it is something important because a lot of people were under the assumption that if I got my guardianship order and my order regarding special findings from a appropriate family court, and I was not from these countries, I would be able to file my application for adjustment of status at the same time as my I-360 or shortly thereafter. That is not the case anymore. Please make sure you're being careful. The only good news is you still can file your I-360. If it is approved, you will have deferral of removal, meaning the government cannot take any action to remove you from the country, and you will also be eligible for employment authorization. Last thing I'd like to mention regarding USCIS is marriage-based adjustment of status applications. We are seeing more and more frequently USCIS not interviewing married couples regarding the green card application. This is not to say that every couple does not have an interview, but if you are submitting a marriage-based application and there is evidence to show that this was a good faith marriage included, we are seeing that USCIS is typically either approving these applications without an interview or in some instances sending a request for evidence for additional bona fide marriage evidence. It's very important to take these requests and submission of such evidence seriously, as it can result in you getting a green card without ever going to USCIS. Why is that good? It takes less time. When you need an interview, it takes longer to finish your case. 2, you get your green card faster. No interview, everything's good and in order, case can be approved, green card comes. So this is important. If you are about to start the process or you've already started the process, we're happy to help you gather evidence that would be helpful for you. A lot of times people think the marriage certificate is enough. That's proof that you're married. But for immigration, that's not. You are required to submit documents to show you guys are living together or that you're planning on building a life together, that this marriage wasn't just so your partner could get a green card. That's all I have for today. Again, if you have questions about anything discussed today or other immigration matters, please contact our office. The number is 212-840-0050. Have a great day.